Greetings, legal minds. One of the problems students face when trying to define whether or not an offer has been made with respect to a particular scenario question in the Nigerian law of contract arises from their inability to distinguish an offer from an invitation to treat. Because most times when you analyze situations that involves the entering of a bus, the entering of a transportation vehicle, the buying of things from a supermarket, the buying of books from a bookshop, and so many other relative scenarios, you would find it difficult to determine when an offer has actually been made. And for the purpose of this tutorial session, we will try to distinguish and outline the distinguishing factors between an offer and an invitation to trade in the Nigerian contract law. Firstly, one of the things you must note with respect to the understanding of contract is that for a contract to be said to have been validly established, there are certain elements that must be in existence, and the inexistence of any of these elements makes that offer invalid in the eyes of the law. As well established by Nikitobi JSC as it then was in Orient Bank and Bilante International Limited, it said that for a contract to be said to have been validly established, 5 essential elements must be proven by the plaintiff or the claimant to be in existence as at the time of contract. This is known as the offer on the part of the offeror, the acceptance on the part of the offeree, the consideration, which is something of value that has been exchanged between parties, the intention of parties to be legally bound, which is inferred from the nature of the contract and the circumstances surrounding the creation of that agreement, and the legal capacities of individuals to contract. Coming to the purpose of this tutorial session, I said one of the difficulties students face when trying to define whether or not an offer has been made with respect to a particular scenario question stems from the inability to distinguish an offer from an invitation to treat. And for the purpose of this tutorial session, we would outline different scenarios that will make you properly understand how these differences can be gotten, so as to ease your ability to distinguish this with respect to any scenario question. Firstly, what is an offer? In simple terms, an offer is an undertaking, is a promise that is made from one party who is known as the offeror to another party with respect to a contract who is known as the offeree, with an intention that this promise that he is making, this undertaking that he is passing, will become binding on him once it has been accepted. This is very clear. An offer comes with an intention to be bound. When it comes to an invitation to treat, an invitation to treat according to law is simply a phenomenon, an action, a promise, or an address that is preliminary to the creation of an offer, which is not made with the intention to become bound, but rather made with a desire. That desire is simply to invite interested contractors so that an offer can be made. From these two definitions, you can identify 3 different distinguishing factors which will make you understand the differences. The first is seen in the nature of the promise or the undertaking. The second is seen in the individual's intention behind the making of that promise. And the last is seen is the goal of that individual when making that promise. In an offer, when it comes to the nature of that promise, an offer is direct, unequivocal, unconditional. When it comes to the nature of an invitation to treat, an invitation to treat is not direct, it is just an advert, it is a phenomenon, it is a mere action that invites interested contractors. When it comes to the intention, an offer comes with an intention to become bound by its terms. But there is no such intention when making an invitation to treat, because you are not binding yourself by the terms, you are just inviting individuals to come and negotiate. And a desire for the making of an invitation to treat is to invite interested contractors so a contract can be created when any of them comes with respect to the invite or adverts that have been made. So, when it comes to the getting of a goods in a supermarket, upon examining the circumstances surrounding the creation of that agreement, you can see that all the individuals, the cashier or the sales individuals in the supermarket did was to invite individuals to come and buy their goods in the supermarket. The promise that was made while displaying that goods is not direct, so it cannot be termed as an offer. Neither did the promise come with an intention to get themselves bound by its ends, so it cannot be displayed or defined as an offer. Examining the nature of an invitation to treat, like I just explained, will make you confidently attribute that circumstances as being an invitation to treat. So when you face any particular scenario question that wants you to either define whether or not an offer has been created or distinguish an offer from an invitation to treat with respect to any scenario, these are the things that you must point out so as to easily make that determination of the issue that has been brought before your desk. All these are just for the major purpose of making you understand the concept of invitation to treat, and during our next lectures we will dive into other controversial topics in the Nigerian law of contract. Stay tuned and follow the MSlegal Nuggets page to be updated when more insightful nuggets and legal tips are sent.